Welcome back to Paralegal America. Today we dive into a tense Senate Judiciary Committee exchange as Senator John Kennedy grills nominees for the District Court of North Carolina. Stay tuned as we break down the most striking moments. Kennedy described a small printing company where an employee wore a burqa with her uniform. He asked, "What if the owner objects but the employee insists on wearing it?" The nominee cited Title VII, which bars discrimination based on religion. Kennedy pressed, "What if it's a safety hazard?" The nominee said safety concerns must be weighed carefully.
Thank you, Mr. Chairman. I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer?
Senator, I would be happy to
Let's just
go
start in the
first.
middle and we'll work to the end. Tell me, Mr. Also?
Orso, yes. Thank you,
Orso, I'm
Senator.
sorry. I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take customer orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burqa. And the owner says, "You can't wear a burqa here." And the employee says, "Yes, I can." And the owner says, "You're fired." Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
And what's Title VII say?
Says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender. And then I would apply the facts of that case, pursuant to
What
any-
facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, sincerely held religious belief. And then if so, would analyze it from there.
What if the employer said, my customers won't like it? Is that a justification?
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that.
Kennedy shifted to the courtroom. He asked about supplemental jurisdiction. The nominee stumbled, admitting it rarely came up. A magistrate judge explained it clearly. Kennedy nodded, highlighting the gaps in others' answers. Kennedy asked a straightforward question. How do you amend the Constitution? The nominee cited Article 5, 2/3 of Congress or states.
Allows for that person to
If
work
the
there.
small business owner said, it's dangerous, the employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something.
Mr. Bragdon. David
Bragdon.
Bragdon, thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe
It's
it's
going to come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember Senator Kennedy.
Okay. Do you know?
Senator, I would say that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's turn your
This is
microphone for me,
Judge Rodriguez, and so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this, so supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets, the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay. We go back to Mr. Orso. How do you amend the Constitution?
think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough.
Then, Kennedy pressed about injunction, preliminary versus permanent. The nominee mostly answered correctly, but wavered on the details. Kennedy turned to class actions. The nominee cited Rule 23. Plaintiffs must show numerosity, commonality, typicality, and adequate representation. Kennedy seemed satisfied, but the exchange showed the importance of detailed civil procedure knowledge.
Let me move to the gentleman to your right. What's the difference between a preliminary and a permanent injunction? How you decide, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure.
to
For a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
You
I
look at
think
the same
that-
factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a
that's
preliminary
pending.
injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
In
so-
a permanent injunction, you're asking, has the party succeeded on the merits?
Correct. My only point is what the merits are is going to vary based on the kind of case.
Fair enough. Counselor, tell me about class actions. What are they and what are the elements of you have to prove?
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors in it.
Senator Kennedy's sharp, hypothetical questions revealed both strengths and blind spots of judicial nominees. The hearing showed the immense responsibility judges hold and the scrutiny they face before confirmation. Like and subscribe for more deep dives into U.S. law and politics.